this development, please take a look. Before 1996, all international legal activity of the Prosecutor General Office, which was generally limited to protocol functions and making requests for MLA, was carried out by just one division with 7 officials. In 1996, the International Legal Department of 12 officials was created. In 10 years, in 2006, it was reorganized into the General Department of International Legal Cooperation, consisting of 3 departments and comprising 77 officials. And at the same time, protocol functions were conveyed to a different division. Until now, they are fulfilled separately. And today, considering the expansion on functions of the General Department of International Legal Cooperation, it consists of 4 departments and 2 self-regulated divisions, comprising 142 officials. Apart from traditional international cooperation powers, in the criminal law sphere, Russian prosecution service execute another powers. Constructively, 3 blocks of international legal powers can be highlighted, and you can see these 3 blocks on the screen: powers in the criminal law sphere, outside the criminal law sphere, and of general nature. Among directions of the international cooperation in the criminal law sphere, the following should be stressed out. First of all, extradition and related issues of international search. And it is important to note that the Prosecutor General or his deputy decides on extradition himself without a court decision. The next is transfer of persons with psychological disorders for compulsory treatment. The procedure is the same. Rendering legal assistance in criminal matters, including transfer of criminal proceedings. And coordination of activity of law enforcement authorities in asset recovery, as well as in implementation of international anti-criminal treaties. As to the coordination of asset recovery activities, I will go into some details, while other powers in the criminal law sphere are quite standard for the majority of countries, so I will not pay special attention to them during this presentation. In our country, when we talk about asset recovery, we stick to a system-based approach, taking effective preventive measures to prohibit illegal withdrawal of assets. I'll give you an example. A few years ago, the criminal scheme of asset withdrawal using court decision became dangerously widespread. A non-resident sued a fictitious debt from Russian company, received a court decision and presented it to the bank, which could not refuse to execute it. To prevent such attempts, prosecutors enter into court process. And if the judicial act has already taken place, they seek its revision according to newly discovered circumstances, presenting evidence to the court about the real intent of actions of the participants of the dispute to legalize illegal income. And thanks to these measures taken by the prosecutor's office, the number of such facts was significantly reduced. However, if despite of the measures taken, assets were withdrawn abroad, a complicated process of their recovery is initiated. This process consists of such stages as the detection, search of assets, their seizure, confiscation, recognition of domestic court decision in requested state, and finally, factual trans-border transfer of assets. For the recent years, we have taken several organizational measures to raise the effectiveness of the process of asset recovery. In 2020, the Prosecutor General of the Russian Federation, by his order, approved a sequential algorithm of actions of prosecutors at all levels on each stage of this activity, from the very search of assets abroad to taking the final court decision and its execution. In order to coordinate the activity of other ministries, agencies and organizations, The interagency working group was created. It comprises representatives of 17 governmental bodies and organizations dealing with the asset recovery process. Leading scientists who deal with this activity also take part at the meeting of this working group. The group develops and improves legal framework, including at international level, provides for analytics, prepares guidelines for investigators and prosecutors, and discusses concrete asset recovery cases to find better solution. Moreover, last year an interagency instruction on the organization of asset recovery activity was adopted by 13 governmental bodies involved on the asset recovery process. This document contains precise mechanism of interaction between all bodies and organizations on this issue. And of course, we are ready to share all these achievements in written if you have such an interest. Organizational measures are taken not only on domestic but also on external, international level. We have prepared a practical step-by-step guide on asset recovery for the foreign competent authorities. It on legal regulation of this process in Russia. It also has all necessary data and practical advice for foreign agencies on how to draft a request, subject to contains information of our legal system. This document was refreshed last year and published in the Russian and English languages on our official website as well as the UNODC webpage. For 14 years, on the basis of the Prosecutor General's Office, the national contact point, focal point on practical international cooperation on the search, seizure, confiscation and recovery of the proceeds from the corruption has been functioning. Recently, a decision to create such focal point net on asset recovery between the BRIC states has been taken, and on behalf of the Russian Federation, it will be also the Prosecutor General's Office. It should be noted that our achievements in asset recovery were positively recorded upon the second review cycle of the mechanism for the review of the implementation of the United Nations Convention Against Corruption. There are also specific practical results. As of today, 45 immovable property objects and financial assets was $400 million were seized by the foreign competent authorities on the basis of our MLA requests. Last year, for the first time, we initiated seizure of cryptocurrency on Binance virtual accounts that keep assets of the criminal community members who created so-called pyramid for stolen people's money. We have several examples of factual recovery of assets to Russia from foreign jurisdiction, as well as the vice versa process on asset recovery from Russia. Unfortunately, today international anti-criminal cooperation is complicated by a destructive position of number of states and international organizations. It causes new problems that affect the process of asset recovery. Among them are following. First, Western countries attempt to use confiscation mechanism for the sake of political environment and in circumvention the procedural requirements of international law. They just appropriate our assets, the assets of our state, our citizens and organizations without legitimate grounds. Second, for the last 2 years, we face politically motivated restrictions of participation of Russian delegations in several international fora on asset recovery. And third is the refusal of some jurisdictions to cooperate and exchange information, including for execution of MLA requests. But we strongly believe that politicization of law enforcement cooperation leads to impunity of criminals. In our point of view, it's inadmissible. At the same time, Russian prosecution service continues fully implement its international obligations and stay open for a faithful and equal dialogue with foreign partners all over the world. Dear colleagues, we have examined the powers in the criminal law sphere And now let me switch to other directions. Outside the criminal law sphere, the Russian prosecution service executes the following international legal powers. First, rendering legal assistance in administrative offense cases, including transfer of administrative proceedings. Unlike the crimes, administrative offenses in our country are characterized by lower level of social danger, including when actions of offenders did not lead to consequences needed for corpus delicti. I'll give you some examples. For example, stealing of inexpensive items, traffic accidents, possession of narcotic drugs in a very small amount without purpose of sale, and so on. Since our legal system does not provide for criminal liability of legal entities or organizations, they can be brought to administrative responsibility also, even when we talk about very serious offenses. For example, intentionally offering, promising, or giving money, securities, and other property or property services to an official on behalf of a legal entity. So in these cases, we also use the mutual legal assistance at the competent authority. The next power is international law enforcement assistance. Opposite to judicial or legal assistance, which is regulated by international treaties and aims to obtain evidence in criminal matters, law enforcement assistance aims to exchange guidance information and documents. It is regulated not only by international treaties, but also by interagency agreements, as we have with Tanzanian partners, which usually have reservations saying that provisions of these agreements do not interfere with MLA. Law enforcement assistance is often used when dealing with applications of citizens and organizations, conducting supervisory inspections without criminal proceedings, requesting information on legislation of foreign countries, exchanging experience and best practices. We also use law enforcement cooperation to send copies of criminal case materials and report crime in order to initiate criminal prosecution abroad. And one of the areas where we often use law enforcement assistance is anti-corruption activity. Russian legislation provides for a number of anti-corruption prohibition and restrictions for public officials. For instance, public officials must declare all real estate property and transport means they own, including those that are located abroad. High-level Russian public officials are also prohibited from having foreign citizenship, foreign bank accounts, foreign securities, and other financial instruments. And if a person violates these prohibitions, he or she is subject to dismissal upon the loss of trust. No doubt that such prohibition and obligations alone are the very good preventive measures to help reduce possibility of withdrawal of the proceeds from crime abroad. In order to control execution of these requirements by legislation, empowers Prosecutor General's office to make requests abroad and to interact with the foreign competent authorities. At the same time, in Russia, violation of this prohibition does not lead to criminal liability. That is why we are not talking about mutual legal assistance. In these cases, we use law enforcement cooperation, referring in our request to our arrangements or agreements with our foreign partners, as well as international treaties, for example, to Article 43 of the UN Convention Against Corruption, which states that where appropriate and consistent with the domestic legal system, states parties shall consider assisting each other in investigations of and proceedings in civil and administrative matters relating to corruption. We have established a good practice of such cooperation with colleagues from all over the world. And information we get from abroad allows us to dismiss public officials, to forfeiture their property to the state budget, and in case where is corpus delicti, for example, elements of bribery, to make them criminally responsible. Outside the criminal law sphere, the Russian prosecution service represents and protects the interests of Russian Federation in interagency bodies, foreign and international courts and arbitrations. This power was granted to the prosecution service just in summer 2021. Previously, it was fulfilled by a number of other authorities, mainly by the Ministry of Justice, Ministry of Sport, and Ministry of Economical Development. As you know from the previous video presentation, the Prosecutor General's Office is the main human rights watchdog in Russia. We have a full set of legal tools and supervise over the activity of governmental, municipal bodies, organizations, and their officials. And that is why transmitting this power to our service from other stakeholders help to improve the effectiveness of such activities. Having this power, the Prosecutor General's Office of the Russian Federation has a unique competence to represent and protect the interests of Russia in such international judicial bodies at the Court of Eurasian Economic Union and in the Economic Court of the Commonwealth of Independent States. We also select and provide nominees for judges at these courts, withholding necessary contest procedures. As to international arbitration, it's well known that it's one of the alternative ways to tackle down disputes. The arbitration can be created for a specific dispute, so-called ad hoc arbitration, or as a permanent institution, institutional arbitration. Generally, the basis for jurisdiction of arbitration is an arbitration agreement between the parties or a reservation to an international treaty. As a rule, agreements on protection and promotion of investments contain provisions for a specific dispute, handling disputes between investor and the state by international commercial arbitrations. When Russia is a party of any international dispute, we represent our country in trial. And there is only one exception, the participation in the International Court of Justice, which is a competence of the Ministry of Foreign Affairs. For example, we represent now the interests of the country in international arbitration at the Permanent Court of Arbitration in The Hague, International Court of Arbitration in the International Chamber of Commerce in Paris, Arbitration Institute of the Stockholm Chamber, and the Chamber of Commerce, and Vienna International Arbitration Center. For these ends, we coordinate the activity of great number of federal public authorities and local administration bodies. It should be noted that Russia is a party to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards of 1958, according to which 172 states parties to the convention are obliged to recognize and enforce arbitral awards, despite the fact whether they are taken by an ad hoc arbitration or a permanent arbitration. That is why this direction of our activity is very important. We also participate in international sport, judicial and disciplinary bodies, where we deal with the cases connected with the protection of interests of our sportsmen and sport organizations. And now the third block of powers, which relate both to criminal law sphere and to activity outside the criminal law sphere. It's the establishment, maintenance, development, and coordination of direct relations between the Prosecutor General's Office of the Russian Federation and foreign competent authorities, as well as international organizations. These powers are executed through participation in international events and holding them, permanent participation and activity of international organizations, drafting international treaties, and conclusion of international arrangements, including agreements, memorandums, declarations, cooperation programs with the foreign competent authorities and international organizations. So let me elaborate on each of them. First of all, international events. Last year, prosecutor participated in more than 550 international events, and the activity level grew more than 50%. Some novelties introduced by us help to raise the activity in this sphere. First, apart from the headquarters of the Prosecutor General's office, subordinate prosecutor offices were engaged in international activity. In particular, last 2 years, arrangement on border steering cooperation with the colleagues from Kazakhstan and China were concluded. The Prosecutor General's Office of the Russian Federation published instructions and guidelines that oblige prosecutors of border trading territories to actively implement their functions aimed at the establishment and development of direct ties with foreign colleagues in concrete forms and spheres. As a result, last year a number of international events with the participation of these prosecutions services raised fivefold. Secondly, permanent joint working groups for close cooperation on specific issues were formed with the competent authorities of a number of foreign states. For example, there is working group with the Prosecutor General's Office of Mongolia, and it is on exchange information on environmental crimes. There is also the working group on combating crime with the Prosecutor General's Office of Iran. There is a working group of investigating genocide against the Soviet people during the Great Patriotic War with the Prosecutor General's Office of Belarus. There are also anti-corruption working groups with another foreign special bodies, and so on. And thirdly, we took measures for breakthrough development of cooperation in research and educational sphere. In particular, the Prosecutor General's Office concluded special international arrangements in this sphere, as well as the University of the Prosecutor General's Office, increased the quote for advanced training of foreign prosecutors. As a result, the geographical scope of implementation of training programs has been raised. Since 2022, at the direction of foreign competent authorities, foreign students started to study at our university in the higher education programs. We took measures to carry out academic exchange and joint scientific research, and holding lectures abroad like this one is also one of our novelty. In addition to presentations during international events, prosecutors systematically participate in the work of international organizations. In the framework of the Commonwealth of Independent States, Russian Prosecutor General was elected for a post of a chairman of the Coordination Council of the Prosecutor General and for a post of the chairman of Interstate Council Against Corruption. Representatives of the Russian Prosecution Service permanently participate in the steering committee of the Global Operation Network of Anti-Corruption Law Enforcement Authorities, GLOBE, the regional anti-corruption net of law enforcement bodies within the Asia-Pacific Economic Cooperation Anti-Corruption and Transparency Expert Working Group, the Russian official delegations for participation in the meetings of Financial Action Task Force and different United Nations formats, for example, Commission on Crime Prevention and Criminal Justice, Commission on International Trade Law, Conference the State Parties to the UN Convention Against Corruption, and so on. According to the law, the Prosecutor General's Office conclude agreements on rendering legal assistance on combating crime, participate the drafting of international treaties. Let me show you an example for our contractual legal activity. You might be aware that in 2019, the UN General Assembly adopted a resolution that created an ad hoc committee to elaborate a comprehensive international convention on countering the use of information and communication technologies for criminal purposes. This resolution was adopted at the initiative of Russia. The draft multilateral convention introduced to the ad hoc committee by Russia was drafted by the Prosecutor General's Office as a leading agency on this issue in our country. The initiative to elaborate such a convention was generated by the practice of international cooperation on IT crimes, which demonstrated law effectiveness of existing mechanism of crime detection, identification of guilty persons, and bringing them to justice. The problem is also in difference of approaches to the criminalization, in the complicated procedures that make examination of MLA requests a lengthy process, and non-regulation of many aspects by the existing international treaties. Politicized refusals to execute Russian requests by Western countries are also a problem. Unfortunately, today, the world community doesn't have a unified approach to the resolution of these problems. There is even no unified terminological basis. That is why we believe that the adoption of such a convention is extremely important for the whole world. To carry out direct communications and cooperation with the foreign competent authorities and international organizations, the Prosecutor General's Office conclude agreements, memoranda, protocols, declarations, cooperation programs, and other arrangements. And as you always saw in our video presentation, there are more than 140 such arrangements, about 150 now. Among priority issues of international activity of the Russian Prosecution Service reflected in such arrangements, I can stress out countering IT crime, terrorism, extremism, corruption, money laundering, including with the illegal use of cryptocurrency and other virtual assets, domestic violence, especially against minors, other violations of